Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, we're in session number 7, our final session in this program entitled The Slippery Slope of Substantial Medical Evidence. And by the end of today's discussion, we will have completed over 6 hours of discussion on this critical topic of substantial medical evidence. Now, I want you to know that you can get this type of a discussion, this depth of discussion on substantial medical evidence nowhere else but here. And I just recently received 2 advertisements for 2 QME continuing education seminars. Both are being held virtually. And both seminars share in common some features in that they include multiple speakers discussing multiple topics over the course of 6 hours. One particular seminar that I'm referencing has as many as 9 speakers over the course of 6 hours. And I noticed that they'll be discussing substantial medical evidence for about 40 minutes in that particular virtual seminar. Well, in today's discussion, we're completing over 6 hours of detailed, in-depth discussion that you can find nowhere else. And you'll find that throughout our programs at Easy Continuing Education, we take an in-depth look at critical subjects that are so important for qualified medical evaluators, that are the types of concepts that qualified medical evaluators typically either misunderstand or have some mistaken information about. And we dissect those topics down to the molecular level so that once and for all we can understand those topics and we can learn to integrate the concepts into our evaluations and into our reporting on our particular cases. And in today's discussion, I want to wrap up the concept of substantial medical evidence and share with you an important case law that will simplify the whole matter for you and take this seemingly complex subject and break it down into some simplified steps for you and show you how you can win the game as a qualified medical evaluator if you can embrace and adopt this concept of substantial medical evidence and learn to think in terms of substantial medical evidence. Think. Substantial medical evidence is a way of thinking. It's going to begin for you as a method of writing, and it will be very mechanical for you, but as you become more and more fluent in providing opinions and conclusions that qualify as substantial medical evidence, you'll become quicker and quicker at thinking using substantial medical evidence as your decision-making system. So I want to share with you a case that illustrates that principle, and then I want to share with you a story from my own qualified medical evaluation practice that will show you how important and how valuable these concepts will be to you in the practical day-to-day duties that you embark upon as a qualified medical evaluator. So I'll share that story with you at the end of today's discussion. And before we get into those 2 matters, let's just briefly review the philosophy of this program and where we've come from so far over the past 6 hours. So the backbone philosophy of this program has to do with define, rely, integrate, relax, and improve. And we begin by defining the criteria that will qualify your opinions and conclusions as substantial medical evidence. And those criteria were just defined in these historic cases and others, but these are the historic cases that we rely upon for the component parts or the elements of your opinion that will qualify your opinion as a substantial opinion. And we stated throughout sessions number 1 and through session number 6 that if you can embrace the concepts of substantial medical evidence, you can rely on its tenets to help you arrive at true, accurate, and correct conclusions every single time. In other words, substantial medical evidence is a medical decision-making process that you can rely on, because if you follow the procedures involved in qualifying your opinions and conclusions as substantial, those procedures will lead you every single time to the naturally correct, the naturally right, the naturally accurate opinion based upon the information that you have available to you at the time. Now, that does not mean that your opinion or conclusion will not or could not change if you're provided with new information, but at least based upon the information that's available at the time, if you put that information through the funneling process of substantial medical evidence, what falls out of the bottom of the funnel will always be the correct opinion for the particular circumstances that you have to deal with at the time. I've showed you throughout the course of this program how to integrate substantial opinions into every single section of your report wherein you're called upon to provide an opinion or a conclusion. Now, opinions and conclusions are different from providing facts, from simply reporting facts, such as reporting your findings on range of motion measurements or your findings on reflex testing. Those types of factual findings do not call for opinions or conclusions. Opinions and conclusions are the subjective components of your evaluation, whereas your findings on range of motion testing, those comprise the objective components of your reporting. When it comes to the subjective components of your reporting, where you have to stick your neck out into a gray area and take a stand and take a position and be bold, well, you can rely on substantial medical evidence, and you can integrate into your report, in those sections of your report where you have to stick your neck out, you can integrate substantial medical opinions at those points to qualify those opinions as the correct determination, regardless of what section of your report you're dealing with. And if you can do that, you can relax. You can relax and not worry about this report coming back to haunt you because you made decisions based on emotion that perhaps you shouldn't have made at the time. No. When you provide opinions and conclusions based on substantial medical evidence, you remove the emotional component from your medical decision making, and you can relax knowing that you've made the correct decision every single time. And I don't know about you, but I like and enjoy being correct, and it gives me a comfortable feeling at ease inside my person when I know that I'm correct. And I suspect you're probably a lot like me. And then finally, throughout every session of this program, I've shared with you case laws examples where qualified medical evaluators have both succeeded and failed in providing opinions and conclusions that either did or that did not qualify as substantial medical evidence. And by reviewing these case law examples, we see where qualified medical evaluators on the one hand go wrong and fall short in being able to support their opinions and conclusions. And then on the other hand, we see examples where qualified medical evaluators have successfully supported their opinions and conclusions, and therefore their opinions and conclusions can be upheld just as the qualified medical evaluator intended when he or she authored her report. See, it's our intention as qualified medical evaluators that the case settle in accordance with the opinions and conclusions that we offer. That's our intention, correct? That's our hope. Our hope is that the case will settle based upon our opinions and our conclusions. Well, qualified medical evaluators can either succeed at that or they can fail at that. And I've shared with you several examples of both. And I have a fascinating example for you today wherein the qualified medical evaluator succeeded greatly. In fact, he succeeded in basically quintupling, which is 5 times. Multiplying by 5 is quintupling. He quintupled the permanent impairment rating under the strict application of the AMA guides by providing an alternative impairment rating under Almaraz and Guzman, and he successfully supported it, and the examinee was awarded a 5 times higher permanent impairment rating based upon his successful support of his opinions and conclusions. Okay, so that's the philosophy of this program, and I hope you can embrace these ideas into your very next evaluation. And let's just briefly summarize sessions 1 through 6 before we get into today's discussion. Okay, so let's review where we've come from so far in this program. In session 1, we went over the case law definitions of substantial medical evidence, and that had to do with those historic cases, the Garza case, the Escobedo case, the Zemke case, okay? So it's important that you remember what are the definitions of substantial medical evidence. So you should commit these to memory, and you should be fluent with this, and you should think of these definitions every time you offer an opinion or conclusion in your report. So what are they, okay? So number 1, substantial opinions are based upon reasonable medical probability. Number 2, they explain how and why reasoning in support of the opinion or conclusion. Number 3, substantial opinions are based on an adequate history. They're based on an adequate examination. Substantial opinions provide relevant facts in support of the opinion and conclusion, and substantial opinions are not based on guess, conjecture, speculation, or surmise. Okay, and we're going to come back to these with an example at the end of today's discussion. So it's important that you remember those particular defining components of substantial medical evidence. In session number 2, we took those ideas and we applied them to the causation determination, which is especially applicable today when we're seeing so many denied cases, including the post-employment cumulative trauma denied cases where you as the qualified medical evaluator are called upon. In other words, the reason the evaluation is called for is so that you can provide an opinion as to whether the examinee qualifies or does not qualify for workers' compensation benefits. And this is where your AOE COE determination has to be correct every single time. It has to be correct. You do not want to make the wrong decision on AOE COE ever. And I showed you how you can be correct every single time if you just follow the system of qualifying your opinion either for or against industrial injury as a substantial opinion. In session number 3, we went over a couple of important cases, actual cases, where the qualified medical evaluator's opinions were found to be not substantial. And the opinions and conclusions of the qualified medical evaluator could not be used in the resolution of the issues in dispute in the case. And one of those cases had to do with industrial causation, AOE COE, and it was found that the qualified medical evaluator had some incorrect legal theories about cumulative trauma injuries, and he had to be replaced. And the second case had to do with a permanent impairment argument wherein the qualified medical evaluator failed to be able to explain how he arrived at the permanent impairment rating, and so his permanent impairment rating was found to be not substantial. In session number 4, we talked about substantial medical evidence and the apportionment determination, and an important principle from that discussion was how so intricately linked the apportionment determination is to the description of the permanent impairment. And let me say that another way. What was important from that session is that how you describe the permanent impairment, how you formulate the permanent impairment, which chart, chapter, or table you use to describe the examinee's permanent impairment determines the apportionment determination. And you can have one description of permanent impairment that is subject to small, medium, or large apportionment, whereas if you describe the impairment using another method, another use of language within the 4 corners of the AMA guides, your permanent impairment rating could escape apportionment. In other words, the apportionment determination is intricately linked to your description of the permanent impairment. So that was a valuable lesson that you may be able to take advantage of in your very next evaluation. In session number 5, we talked about, again, substantial medical evidence and your permanent impairment determination. And we started to break down how to qualify your opinion and conclusion on permanent impairment based upon whether or not that opinion or conclusion comes from the strict application of the AMA guides, or whether your permanent impairment opinion comes from an alternative impairment rating under Almaraz and Guzman. And they both have different languages that they employ in qualifying those opinions and conclusions as substantial. Then in session number 6, our last session, we went into even more detail about a specific system that you can use when you want to provide for an alternative impairment rating under Almaraz and Guzman, which has the effect of doubling, tripling, quadrupling, and quintupling, and even beyond the impairment rating. So, of course, that high permanent impairment rating is going to attract scrutiny by the parties and the payers, and therefore, if you intend for that permanent impairment rating to be upheld and to be the permanent impairment rating upon which the parties resolve the examinee's permanent disability award, it has to be done correctly, or else the rating simply will not stick, because the parties will conclude that you're simply trying to achieve a higher rating when that higher rating is not accurate, and it's not accurate because you fail to be able to demonstrate the support for that rating. So I shared with you how to provide the support for an alternative impairment rating. And in today's session, we want to take all of these principles that we've discussed so far in this program and share with you a crazy case. I consider it to be a crazy case, but it's a crazy case that resulted in a win for the examinee, and it resulted in a win for the Qualified Medical Evaluator, who provided a 5 times higher permanent impairment rating than was provided for under the strict application of the AMA guides. And it's a crazy case because it illustrates really how simple it is to provide for an alternative impairment rating, and how simple it can be for you to provide enough support for your higher rating to have that rating succeed as a substantial opinion. And I think this type of a case gives us great hope for our own cases wherein we feel that the examinee qualifies for a higher permanent impairment rating under Almaraz and Guzman, and the hope is that it's not so difficult to do. The hope is that we can do it, that we can provide the support necessary to have our opinions and conclusions adopted by the parties. Okay, so let's begin today's discussion with a review of the Case versus Golden Gate Bridge case. Okay, so this is the Case versus Golden Gate Bridge case. And Case was a 62-year-old male bus driver, and he suffered injury to his bilateral shoulders. The bilateral shoulders. Now, as you think of injury to the bilateral shoulders, how would you rate impairment of the shoulders? There's basically 4 impairments that apply to the shoulders. Number 1 is loss of range of motion of the shoulders. Number 2, loss of strength to resisted manual muscle testing in 6 ranges of testing of the shoulder. Number 3 is any findings for shoulder instability. Shoulder instability qualifies for permanent impairment. And then also, in the case of a surgical procedure, a resection of the distal clavicle would qualify for permanent impairment of the shoulders. Okay? So there are 4 basic rating methods for impairments of the shoulders. Well, the medical evaluator in this case diagnosed bilateral shoulder tendinitis. So it sounds like, based on that type of a condition, a rotator cuff tendinitis or a biceps tendinitis, sounds like indeed the examinee would probably qualify for an impairment rating under one or more of those 4 criteria: loss of range of motion, loss of strength, instability. He wouldn't qualify for a resection of the distal clavicle because there was no surgical procedure. And indeed, the medical evaluator rated Mr. Case based upon loss of range of motion. So for the right shoulder, the medical evaluator provided for 2% whole person impairment due to loss of range of motion. For the left shoulder, he provided for 3% whole person impairment due to loss of range of motion. And combining those would probably come out to be about 5% whole person impairment. So that was the final rating for Mr. Case under the strict application of the AMA guides, was 5% whole person. Well, then the medical evaluator felt that the permanent impairment rating under the strict application of the guides was not the most accurate rating of Mr. Case's impairment, and the medical evaluator provided an alternative rating for 12% whole person impairment, 12% for each upper extremity, a quintupling. 12 plus 12 is 24. He provided originally 5, so 5 into 24 is roughly a quintupling of the permanent impairment rating as an alternative rating. Well, of course, this drew the scrutiny of the payer and the defendant objected, claiming that the alternative impairment rating was not substantial medical evidence. Now, what we're going to see as we quickly review this case is that the medical evaluator did a couple of things to which the defendant sunk his teeth into, his or her teeth, and used as the basis for the objection. Number one, the medical evaluator provided an alternative impairment rating due to loss of grip strength. He used grip strength rating to rate a shoulder injury, and the defendant had a little trouble wrapping his mind around that, so the defendant objected to that. And then secondly, in providing for the impairment rating due to loss of grip strength, the medical evaluator used the chart and table in the AMA guides. The only problem with that was that the chart and table in the AMA guides only rates examinees up to age 59, and Mr. Case was aged 62. So the defendant objected to this also. So the defendant objected to the use of grip strength testing. And further, in the context of grip strength testing, the chart and table in the AMA guides does not even discuss normal strength values for a 62-year-old compared to 59-year-olds. So the defendant had adequate basis to object to the examinees or to the medical evaluator's alternative impairment rating. Okay, so let's see how this case was eventually resolved. Okay, so let's read from the case, and these are take-home principles for you to remember when it comes time for you to employ alternative impairment ratings. And the take-home principle is that you have tremendous latitude in using the four corners of the AMA guides if you can simply provide some basis or support for your alternative impairment rating. So the Appeals Board tells us that an alternative rating instead of the strict rating may more accurately reflect an applicant's impairment in those complex or extraordinary cases involving conditions that are manifested only by subjective complaints, such as the officer's plantar fasciitis in Cannon. And we discussed the Cannon case a couple of sessions ago. However, we discern nothing in Almaraz, Guzman, and the related case law that restricts an alternative impairment rating to only those complex or extraordinary cases, because that reading would conflict with Cannon. The goal, and here's the take-home message, doctors, the goal is to achieve the most accurate rating of the employee's impairment based upon a medical opinion that constitutes substantial evidence. Now, everyone involved in the case has the same objective, and that is to arrive at the most accurate rating of the employee's impairment. No one has any problem with you perusing the four corners of the AMA guides to come up with an impairment rating that is the most accurate rating The only qualification is that your opinion, it must constitute substantial evidence. If you can provide an opinion that constitutes substantial evidence, the alternative rating will be upheld. If the strict rating does not accurately reflect the employee's impairment, the physician may use his or her judgment, training, and experience to provide an alternative rating from within the four corners of the AMA guides. So let's see how the medical evaluator in this case formulated his alternative impairment rating. The medical evaluator stated, and this is from his report, he said, under Guzman, for his shoulders, the above noted impairment ratings are inaccurate because while they do take into account range of motion, they do not account for strength loss. Now, the impairment rating due to loss of range of motion came in at 5% whole person impairment, 3% for the left shoulder, 2% for the right shoulder, but he states here they do not account for loss of strength, and it's very, very fascinating. He says to correct for that, I turn to table 1632 on page 509, and I note that Mr. Case's right hand grip strength would be expected to be 45.9 kilograms. His best effort was 30.1 kilograms. Applying the strength loss index formula, that results in a 34% strength loss index, which converts to 12% whole person impairment rating, which is the accurate rating for the right shoulder. Now, as we're going to see, the defendant had a problem with this being considered the normal grip strength value for Mr. Case at 62 years old, when this value applies to 59 years old, 55 to 59-year-olds, and 62-year-olds are not included in table 1632. So that's one objection that the defendant had. The second objection that the defendant had is, why in the world would a grip strength loss be used to assess an impairment of the shoulders? And this is where really the whole world opens up to us as qualified medical evaluators, and that we can provide alternative impairment ratings for conditions that the examinee has not had, for injuries the examinee has not had, as long as we can create an analogy and as long as we can support the analogy with an opinion that's a substantial opinion. And in this case, the opinion was found to be substantial. So let's continue. He states, likewise for the left shoulder, he would be expected to have 43.5% kilograms of grip strength. He had a 31% grip strength loss index, which again is a 12% whole person impairment. So by using loss of strength rather than loss of range of motion as the impairment method, the total whole person impairment was basically quintupled compared to the impairment rating provided for by loss of range of motion. And here are tables 1632 and 1634. You'll notice that the table only includes individuals as high as 59 years of age, whereas Mr. Case was 62 years of age at the time of rating. And the medical evaluator used normal values for younger men, when, according to this chart shows a progressive loss of strength going through the decades between 2029 and eventually through 5059. So it's conceivable that Mr. Case at 62 years of age would have much lower values than these normal values for males between the ages of 50 and 59. So that was one contention that the defendant raised upon the appeal to this case. Well, the medical evaluator provided for somewhere between 31 and 60% strength loss index for both upper extremities. That resulted in a 20% upper extremity impairment for both extremities. and that converts to a 12% whole person impairment for each upper extremity. So the workers' compensation judge, he had a problem with these alternative impairment ratings, and the workers' compensation judge provided rating instructions to the rater down at the disability evaluation unit to use the impairment values from the strict application or from the medical evaluator's strict impairment rating, which was 2% for the right upper extremity and 3% for the left upper extremity. And the workers' compensation judge told us that the medical evaluator's alternative impairment rating was also rejected because it was not within the four corners of the AMA guides. So the workers' compensation judge basically had two problems. Number one, he didn't understand why a grip strength loss rating would be applied to an examinee who had injuries to both shoulders, for which the diagnosis to both shoulders was bilateral shoulder tendonitis. So this opens up a whole can of worms and a whole world of opportunity for us. This raises the question, if grip strength loss can be used to assess for shoulder injury, what else could be used to assess for shoulder injury? Could some impairment rating method from Chapter 15, the spine chapter, be applied to shoulder injuries? Could some method chart or table from Chapter 17, which is the lower extremity chapter, could one of those methods, one of those rating methods be applied to shoulder injuries? In other words, this opens up a whole world of opportunity. If the medical evaluator can succeed in employing a grip strength loss rating for shoulder injuries, what else could we use to define impairments for shoulder injuries? It's quite interesting. Well, the appeals board rebuked the judge's opinion. They stated Dr. Mandel, the medical evaluator, did stay within the AMA guides. They say, in his report, Dr. Mandel found that the applicant's range of motion impairment ratings did not account for his strength loss. Now, in his report, all he stated was that the range of motion impairment ratings did not account for strength loss. He didn't explain how they didn't account for it. They didn't explain why they didn't account for it. In other words, we would expect a person who has limited range of motion of the shoulders, we would expect them to have some strength loss of the shoulders, correct? We would, especially in those ranges of motion wherein the range of motion is limited. We would expect the strength in those ranges to be limited as well, but Dr. Mandel did not discuss loss of strength of the shoulders. He uses loss of strength of grip strength in providing his alternative impairment rating, which is just absolutely fascinating. Accordingly, the medical evaluator provided impairment ratings for both shoulders, utilizing the grip strength loss table on page 509 of the guides, and applying the strength loss index formula from the same page. Therefore, the alternative impairment ratings assigned by the AME were indeed expressly from within the four corners of the guides, whereas the workers' compensation judge felt that they were not from within the four corners of the AMA guides. And the appeals board went on to state that the workers' compensation judge's report states that these ratings are not within the four corners of the guides because Table 1632 does not provide data for individuals over 59 years old, and the applicant was 62 years old at the time of the evaluation. Well, the appeals board explains that while Almaraz Guzman does not permit a physician to manipulate the guides to achieve a more favorable result, the physician is allowed to exercise his or her judgment, training, and experience in evaluating impairment using the guides, even if that is possible only by resorting to comparable conditions described in the guides, and in this case, he resorted to comparable individuals aged 50 to 59 described in the guides. A rating by analogy to another condition is precisely that, It's an analogy to a condition the employee may not have, but that has a similar effect on the employee's activities of daily living. So in this case, the grip strength loss has the same impact, or describes the same impact as the impairment that Case suffered to his bilateral shoulders. Almaraz Guzman ratings have previously been upheld as supported by substantial medical evidence, even where the chapter, table, or method would otherwise not be applicable, to the employee's condition. So here, the entirety of the AMA guides open to us and allow us to use any chart, any table, any chapter in the AMA guides, as long as an analogy to at least to similar effect on activities of daily living can be supported. The Appeals Board tells us that to restrict the guides, the use of the AMA guides, to only those cases where the applicant's condition, age, or other distinguishing factors neatly fit into the chapter, table, or method being applied would render Almaraz and Guzman meaningless. The test, and here's the take-home message, doctors, the test is whether the alternative rating is within the four corners of the guides, comma, and is substantial medical evidence that may be relied upon to support a decision regarding permanent disability. And that's all you need to do in order to qualify your opinion as substantial medical evidence, doctors, is to provide an alternative impairment rating within the entirety of the four corners of the AMA guides, and then support that opinion or conclusion by creating an analogy to similar impact on activities of daily living as another condition that you're referencing in another chart, another chapter, and another table of the AMA guides. And in conclusion, therefore, the Appeals Board tells us that the medical evaluator found that the strict ratings of the applicant's bilateral shoulder impairment take into account range of motion, but they do not account for strength loss. Dr. Mandel, the medical evaluator, measured applicant's grip strength for both upper extremities as part of his examination, and utilizing these measurements, he provided impairment ratings using Table 1632 and the strength loss index formula, which refers to grip strength loss, in the AMA guides. Consequently, the medical evaluator explained why the strict ratings did not accurately reflect the applicant's impairment, and he utilized his judgment, his experience, and his training to provide alternative ratings from within the four corners of the guides that more accurately reflect the applicant's impairment, and he supported his alternative impairment rating with an opinion that, at least in this case, which is fascinating to me, is a fascinating learning principle for us all. This case, the Appeals Board felt that his support for the alternative impairment rating did indeed qualify as substantial medical evidence, and the permanent impairment rating consequently was quintupled, basically from 5% under the strict application of the AMA guides all the way up to 24% whole person impairment as an alternative impairment rating. So doctors, what do you think of that? Let's summarize the case. Here we have a case where Mr. Case is a 62-year-old male with bilateral shoulder tendinitis. Is there anything unusual about that? 62-year-old with bilateral shoulder tendinitis. Some research references cite shoulder tendinitis and degenerative conditions of the shoulder to be a natural consequence of aging. It's the natural degenerative condition of the shoulder to develop shoulder tendinopathies and osteophytes and degenerative changes even of the acromion of the scapula, if you can believe that. So herein we have a case where there's nothing unusual, at least clinically. And under the strict application of the AMA guides, using the specific method described in the AMA guides, in the specific chapter Chapter 16, the upper extremity chapter, the examinee qualified for only 5% whole person impairment due to loss of range of motion of the shoulders. Well, using an alternative impairment rating unrelated to the shoulders, the medical evaluator used a grip strength method of determining impairment. He provided for 5 times a quintupling of the impairment rating, and it was upheld. So what's the take-home message? The take-home message is, this is not difficult. This is not hard. This is not something you need to belabor indefinitely. You simply need to get down to providing your opinions and conclusions and supporting those opinions and conclusions in a way that can qualify them as substantial medical evidence. And if you can do that, you can win big in this game as a qualified medical evaluator. So remember, the definitions of substantial medical evidence will never let you down. If you predicate your opinions and conclusions on reasonable medical probability, if you predicate those opinions and conclusions on relevant facts, if you provide how and why reasoning in support of your opinion and conclusion, and if you can confirm to yourself that your opinion and conclusion is not based in any way on guess, speculation, surmise, or conjecture, you can win. And if you can learn to rely on this procedure of qualifying your opinions and conclusions as substantial medical evidence, you can come up with the correct and accurate determination every single time without fail. You will always end up with the correct and accurate decision when you take your decisions through the filters of substantial medical evidence, the filters of reasonable medical probability, the filters of relevant facts, the filters of how and why reasoning. What falls out the bottom is always the true and correct determination, and you can rely on it every single time. Then, if you integrate substantial opinions and conclusions into your report, you can relax knowing that you've made the correct determination every single time, at least based upon the information that's available to you at the time. And let me share with you an example from my own experience. And this is a very recent example that goes back only 4 days. 4 days. This is being recorded on a Tuesday. And just four days ago, on a Friday, I myself had a deposition. And I'll share with you very briefly the learning principle from that deposition. In this particular case, I provided for 4 opinions and conclusions. There was 4 determinations that were the end result of this particular case. And it's not important that we discuss what those were, but the parties called for a deposition, and the deposition was finally held last Friday. Well, as the defense attorney, began the deposition, she went to work on my 4 opinions and conclusions. Now, my 4 opinions and conclusions were basically divided in half. 2 of the opinions and conclusions favored the defense attorney. In other words, I provided for no permanent impairment for 2 body parts, and I provided for some permanent impairment without apportionment for a couple of body parts. In other words, she found 2 opinions and conclusions that she appreciated, and she found 2 opinions and conclusions that she wanted to attack, or at least gain some leeway on. So, as the deposition began, she began to go to work on the 2 opinions and conclusions that she appreciated, the ones that benefited her as the defense attorney. And she went through various pages and stages in my report relating to those 2 opinions and conclusions to qualify those opinions and conclusions as substantial medical evidence. So regarding opinion and conclusion number 1, she went through my report and she said, Doctor, with regards to your opinion and conclusion on, let's say, the cervical spine, did you take a history from Mrs. Jones? And I said, yes. And she said, did you do an examination of Mrs. Jones? And then she went to another section of the report and she said, in providing your opinion and conclusion, I noticed that you explained how and why you arrived at that determination. Is that correct? And all I had to say in response to these questions were yes, and yes, and yes. And I realized what she was doing is she was qualifying my opinions that favored her as substantial medical evidence, right? Now, there's two types of opinions in this business. Opinions that favor one party and opinions that disfavor the same party. There's only two sides to the coin, correct? Well, what are the parties going to do when they find opinions that favor them? They want to have those opinions and conclusions upheld, so they work on qualifying those opinions and conclusions as substantial medical evidence. On the other hand, when she got to the other two opinions and conclusions in my report that did not favor her, she went to work to disqualify those opinions as substantial medical evidence. And she got to opinion number 3, and she reviewed the opinion and she read the passages from my report. And then looking me straight in the eye, she said, "Doctor, isn't it speculative to provide that opinion or conclusion? Isn't it speculative?" And for a moment, I was like a boxer hit in the solar plexus with a Mike Tyson punch to the gut, and I was momentarily stunned, and I found myself quickly going through the substance and the content of the opinion and conclusion and wondering if I had any speculation or how did I arrive at the particular opinion and conclusion. And I found myself momentarily like a deer in the headlights. And then it struck me. Ding, 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 ding. It went off in my head that what she's trying to do is she's trying to disqualify my opinion and conclusion as speculative, based on surmise, based on conjecture, based on guess, etc. She was trying to qualify it as not substantial medical evidence, which is what she's supposed to do, correct? Correct? Okay? So I realized this a little bit too late, but at least I did realize this, and I'm sharing this with you so that you will realize what's happening sooner than what I did, and that you can handle it accordingly. But I did realize it, realized what she was trying to do, and I came back at her and I said, "No, it's not speculative." And she said, "Well, why is it not speculative?" And I said, "Well, because number one, I predicated my opinion on reasonable medical probability. Number two, my opinion is based on relevant facts from the history, from the mechanism of injury, and from the known condition." In this case, the examinee suffered a component of post-concussion syndrome, and I said it's based on relevant facts about the known clinical presentation of patients with post-concussion syndrome. And further, I explained how and why reasoning in support of my opinion and conclusion. In other words, I simply cited the definitions of the components that qualify an opinion as a substantial opinion, to which she said, "Okay." And that was the end of the matter. She no further pursued opinions 3 and opinions number 4 because I provided the component elements to qualify the opinion without actually getting into the content and the formulation of the opinion. I simply provided the component aspects of substantial medical evidence and applied them to my opinion and conclusion, and she realized that indeed those opinions would be upheld because indeed they did qualify as substantial medical evidence. So doctors, I hope this helps you. The concept of substantial medical evidence is so important to your reports and is so important to your future as a qualified medical evaluator, because these elements, these component parts of substantial medical evidence, are the ingredients that you're going to employ in order to win in every single case that crosses your desk. You can win as a qualified medical evaluator, and the way you win is by providing an opinion and a conclusion in your report that will be upheld by the parties, that will be used in the resolution of the disputed issues in your case. And you do that by qualifying each and every opinion in your report as substantial medical evidence. So I hope this helps you now and into the long future of your career as a qualified medical evaluator. So I want to thank you for your commitment to excellence. I want to thank you for joining me on this program. I look forward to being with you on future programs as well. And for now, this is Dr. Perry Carpenter wishing you best of success in your career as a qualified medical evaluator.